Mate, please, your lordship. Mate,
Yes.
I'm praying for listing of unlisted motion today, if lordship permits, my lord.
What is this about?
Urgency is that, my lord, my bank account has been freezed by GST officers, my lord.
Hmm?
GST authorities has freezed my bank account, my lord.
Tomorrow.
Tomorrow, my lord.
Supplementary list for motion, item number 14.
May it please your lordship. My lord, this criminal petition is for invoking inherent power of this honorable court.
I don't know. Yes.
Yes, your lordship, this criminal petition is to challenge the order passed by the Special Court, Prevention of Corruption Act, my lord. I am one of the accused persons. There are 6 accused persons and I am one of them. And the reason why we are challenging this impugn order is that, your lordship, by passing the impugn order, which was passed at the time of opening of the case by the prosecution under section 249 of BNSS, the learned trial court had directly decided to frame the charge by saying that prima facie case was found against all the accused persons. By bypassing that mandatory provision, that is section 250 BNSS, under which I, being one of the accused persons, needs to be given an opportunity of being heard, whether I should be discharged or not. And apart from that, I have also filed the discharge
Whether
application.
you file discharge with the petition,
Discharge application also we have filed, my lord.
that was not heard.
Now, when
No,
it
no.
was,
Whether this discharge petition
now
was
it is still pending, my lord. When it was about
that
to be,
was heard or not before primary?
not yet, not yet. When it was about to be heard, we have realized that that order, the impugn order, was already passed at the time of opening of the case by the prosecution, by directly saying that the court, the learned trial court, has found the prima facie to frame the charge. That means the learned trial court bypassed that section 250, wherein we should be given, our discharge application should be heard, as well as we should be given an opportunity of being heard.
Let us see the impugn order.
Yes, my lord. Lordship, just next to the index, page alphabetical, that I have numbered it alphabetical wise, my lord. A. I'll just read your lordship petition. Special PP, Mr. C.L. Foxwell, and additional PP, Mr. C.L. Rinchunga are present on behalf of Mizoram Lokayukta. A1, A4, I am the A4, my lord. A5 and A6 are present with their
Present
respective
with the
counsel.
council, so they?
Yes.
Then?
And the third para, your lordship, third paragraph, I'll just come to this third paragraph. Today is fixed for opening of the case. Accordingly, the court heard presentation of special PP about the matter of the case and how they are going to prove their case with evidence before court. The court also heard the defense counsels. After hearing both sides' submissions, the court find prima facie case to frame charge.
See, the court also heard the defense counsels.
Yes, this hearing is not, however, this hearing is not as per section 250 of BNSS.
What is how the hearing of the section 250 is to be heard then?
Then discharge application, if it has to also to be
Nowhere
considered.
mentioned here.
Yes, because we are still having the liberty to file discharge application within stipulated 60
No,
days.
have you filed or not filed?
At this time, at the time of passing of this impugn order, we did not yet file that.
Then
However, your lordship, stipulated period of 60 days to file the discharge application, which liberty was given by this BNSS, then that period was still there. In spite of that, this impugn order was passed, saying that directly.
No, it's not. Is it really necessary that each and every one should file discharge petition?
Yes. If,
Kindly
if,
let us see the provision.
if we are willing to file it, my lord, liberty is given to us. That cannot be skipped. That provision
Liberty is
cannot
given by whom?
by this act itself, BNSS.
Okay, not by the court.
Yes.
But then you did not avail the liberty.
No, we were still having 60 days stipulated period. at
Oh,
that
that
time.
means you
Yes.
mean to say that before
Yes.
60 days, charge cannot be framed.
Yes. This is
I
what
have n- I-
this,
I don't
this is
know.
what the law says, my lord.
I have no idea.
May I take your lordship to section 3?
So that, just a minute.
Yes.
So that means charge has to be framed, even if the charge sheet has been filed, the charge has to be framed only after 60 days.
No, your lordship, what I'm saying is that Yes, there is not specifically mentioned by the BNSS. However, after opening of the case under section 249, my lord.
Where is it?
BNS or CRP?
Yes,
Okay, this is
I think if we read the BNSS, your lord.
256.
249. I'll start from 249.
Just a minute. This is
Trial before a court.
corresponding CRPC.
Yes, under CRPC. This I'm referring to BNSS because the trial was.
Just a minute.
Under CRPC, that is 226.
Just a minute. So we are reading 249.
Check. Yes, your lordship. 249.
249.
249.
What is that?
This is the opening case for prosecution. If I read the provisions, it will be very clear, my lord.
Yes.
May I read, your lordship, 249? When the accused appears or is brought before the court in pursuance of a commitment of the case under section 232 or under any other law for the time being in force, the prosecutor shall open his case by describing the charge brought against the accused and stating by what evidence he proposes to prove the guilt of the
Yes.
accused. That was done. At this stage, that impugn order was passed. And I'll come to 250, my lord. Section 250. The accused may prefer an application for discharge within a period of 60 days from the date of commitment of the case under section 232. In respect of the present corruption case, special court, there is no such commitment from the magistrate. But stipulated 60 days should be counted from the date when the charge sheet copy was given to us, my lord. So we had filed the discharge application still within the stipulated time. I'll continue reading, my lord. 250 sub clause 2 says that if upon consideration of the record of the case and the documents submitted therewith, and after hearing the submissions of the accused and the prosecution in this behalf, the judge considers that there is not sufficient ground for proceeding against the accused, he shall discharge the accused and record his reasons for so doing. This 250 was bypassed by the learned trial court. And my lord, I'll come to 251. 251 says, my lord, if after such consideration and hearing, as aforesaid, the judge is of opinion that there is ground for presuming that the accused has committed an offense, which is not exclusively triable by the court of session, so and so. I'll skip this part. That means only after consideration and hearing, which has been mentioned under 250. That is, discharge application should also be considered along with all the relevant documents in the charge
You
sheet.
said that you, till then, you did not file discharge
But
application.
still, my lord, then right away the learned trial court cannot proceed towards 251 because 60 days stipulated period is there.
So, what my question, specific question.
Yes.
That means before expiry of 60 days, the learned court cannot frame charge under 228.
That is what it appears from this
CRPC.
BNSS. Exactly. It appears from this BNSS. Because in the CRPC,
Can you just satisfy the court by showing the authority? Where it says so? Anyone?
yes,
High Court, Supreme Court, any.
we'll try to get it, but by reading this section 250 subsection
It
1
doesn't
itself-
mean that.
Yes.
If you file, then your discharge application is to be disposed of first.
Yes.
But you have not filed any discharge application till then.
Then still
But
your
by
lordship-
then the court has gone for this 228, 252.
your lordship, my humble, yes.
On that day also you could have prayed before the court. I have filed because you knew that it is fixed for the case is fixed.
I understand. I
Then-
understand that part. Despite that, your lordship, if we look at
No.
section 250, if we look at section
Or if you try
250,
to explain that way, it will be difficult then. Then the court will not proceed. If you say that the court cannot proceed within 60 days for framing of charge, it will be difficult.
still your
You have
lordship,
to satisfy.
yeah, I understand your lordship's point, However, Lordship, by reading section 250 subsection 2 itself, it also says that upon consideration of the record.
So you
and
but upon consideration, yes, upon
Yes,
consideration. If
there
you
was
file
no
the
consideration
discharge
of the
petition,
record.
if you file a discharge petition, upon consideration,
No, of the case and,
If
the,
you had
and the
filed.
documents submitted, that means the charge sheet itself has also to be examined, along with hearing of the
yes,
accused
at the
persons.
time of framing of charge sheet is to be considered. If there is nothing, you will be discharged. And
But-
if you have separately filed discharge application, that will be considered first. And after rejection, the charge will be framed. Or after discharging some of the accused, the charge will be framed against other accused. If all accused, there is no prima facie case against all the accused, then all will be discharged at that stage only. But then here is the case where you have not even filed the discharge petition. And on that day also you did not make any request that we would like to file discharge petition. You knew from the very beginning that the case is fixed on that particular date. So you could have filed prior or on that day also. On the same day, if you file that I have already filed discharge petition, that may also be considered first. The court will never say no. Court will have to dispose of the discharge petition first.
I understand, my lord.
Then-
the question your
If
lordship,
you understand that,
yes, the question your lordship posed to me, apart from that, my lord, even if we
that
didn't,
I don't know. That I don't know. That
even if
you have to
my lord,
satisfy.
even if we did not file the discharge application yet at that time, but still, what as your lordship has already just said,
That procedure
then-
is unknown to this court.
no, your lordship, what the learned trial court has to follow section 250 subsection 2. That means at least even without filing the discharge application yet at that time, the learned trial court has to consider the charge sheet. What are the documents
That
filed
is
by
what
the-
I am saying. That is under 252. Even if discharge petition is not filed also, if there is no prima facie case against the accused persons for commission of alleged offence, the court will discharge
Yes.
the accused.
after hearing the accused
But
as
here
well
is the case where he has found a prima facie case against the accused and framed charge.
that means the learned trial court did not hurt us, did not hurt the petitioner.
There is a
Yes.
record. There is a record.
Yes.
You were heard.
But charge sheet was not examined, my lord. That hearing,
Charge, after examining the charge sheet, only the court will come into the conclusion that there is a prima facie case. How otherwise he would come into conclusion that there is no prima facie case or there is a prima facie case? He must have seen the charge sheet. Thereafter only he found that there is a prima facie case against you.
no, that hearing, after hearing the
After hearing,
after
you were
hearing the
heard.
defense counsels,
Your counsel
that was-
were heard.
but it was not heard under this section 250, my lord.
Oh, but you have not filed any application, you said.
But still, there was no mentioning of the examination of the record and all. It was merely stated as the defense counsels were also heard, my lord.
There will be difficult. Unless you satisfy, there will be difficult.
Then I'll try to convince your lordship by, as your lordship has said, your lordship, I'll just try to find some citations also in that regard,
Okay.
regarding the stipulated period of 60 days.
Okay, then what do you want then?
Then it may be taken up tomorrow. And yes, and the next one is similar case, your lordship permits
Three.
my learned friend to
Ah.
make another submission
You
also. my
have
lord.
some
The
other,
similar- similar
other than
method.
this,
Item 2 is
same
the-
submission
the next item.
or you have some other point?
May it please your lordship, this item number, the next two items in fact relates to the same case but different accused. So just to buttress what my learned friend had already submitted, what I mean to say, what my learned friend, in my humble opinion, what my learned friend was trying to impress upon this honorable court was that, as can be seen from the order itself, in the third paragraph of the order, dated, is your lordship referring to item 14 or 15? 15. That would be at page 41, annexure 3.
Yes.
So our interpretation, your lordship, what my learned friend was trying to impress upon this honorable court, and our interpretation is that in the third paragraph, it says, today is fixed for opening of the case.
Prosecution has to open the case.
Correct.
That is true.
Correct. So this was never the stage of framing of charges. Now, my humble understanding is,
What do you mean by opening of case?
opening of the case is basically when the prosecution makes their submission that we have filed this charge sheet, this FIR, ABCD against this accused number 1, 2, 3, 4, 4, 5, And we will be proving
earlier 207 complied. Copy furnished.
yeah, copy furnished, copy
Okay.
furnished. So the
And
first
then,
day,
and then you were asked that thereafter only the advocate was engaged.
correct.
What is the next date then?
My lord.
After that, after furnishing, after
After-
compliance with the 207 of CRPC.
After 207, next comes opening of the case.
Okay, what is that stage then?
The opening of the
Maybe it is
case
not
is,
for the charge, no.
opening of the case, it has nothing to do with the defendant. It
No.
has nothing to do with the defendant.
Can you just explain it once again?
Yes.
The opening of the case?
All right. Opening of the case as per section 249 has nothing to do with the defense. It's basically a stage between the prosecution and the court. Nothing to do with the defense. My lord, may I read again? 249.
Yes.
When the accused appears or is brought before the court in pursuance of a commitment of the case under section so and so or under any law for the time enforced, the prosecutor, not the defendant, the prosecutor shall open his case by describing the charge brought against the accused and stating by what evidence he proposes to prove the guilt of the accused.
Okay, then explain this.
Yes.
Describing the charge brought against the accused and
Correct.
stating by what evidence
He proposes to
proposed
prove
to
the guilt of the
prove the
accused.
guilt of the accused.
So this is the stage where the prosecution will inform the learned trial court that, Your Honor, these are the charges that are
So you mean to say that one complete day is to be fixed for this opening of the case.
correct.
So this is not a stage of framing of charge.
No, not at all. That
Not
is what my
not
learned friend was trying to
simultaneously.
impress. So after opening of the case, only then we will be able to file a discharge application based on the statement and submission of the prosecution.
This practice was not there. That's why
This
probably
practice was in fact,
not in my state.
at least in Mizoram, my lord, this is what has been going on.
So in the opening, one particular day is fixed in in Mizoram.
Yes.
Opening
Opening
of
of the case is basically between the prosecution and the court. The prosecution will try to impress upon the court that these are the documents and these are the evidence with which we will be attempting to prove
And
the
thereafter,
guilt.
what order generally used to pass?
Generally, framing of charge as
No. What order on this opening of the case? Or what order used to pass?
they will
court, Lani
make,
court?
they, as is done here, this is wrongly done, in fact. Normally, orders will be passed saying that the prosecution has made a submission saying that A, B, C, D, they'll be utilizing this evidence at page number so and so. That's it.
So that order used to be there.
Yes.
I have never seen that.
That is the practice here. As per 249. Thereafter, in the same order, they will fix a date for framing of charge normally after 30 days. In between that period, liberty, although unwritten, is given to the defense to file their discharge application, provided it is within the limitation period of 60 days. So,
Okay.
similarly, in this case, instead of passing an order saying that fix so and so for framing of charge, straight away,
We need to call for the record then.
no problem.
In that case.
No problem.
Yes,
So,
Lana PP. So is it so? What he is submitting, is it correct?
Your Lordship,
Just a minute. Huh?
Your Lordship, in this matter, the Yukta has their special public prosecutor, so the special public
Okay,
prosecutor
special
will
public
present the case.
Okay. So is the submission made by the land counsel for the petition correct?
My lord, before that, in item number 14, I represent the Mizoram Lokaikta for respondent number 2. Even though the petitioner has impleted respondent number 1, state of Mizoram, I did not represent state of Mizoram. And at item number 15, in my 15 and 16, in my copy, the respondent are the state of Mizoram represented by the special public prosecutor, Gauhati High Court. This is the copy that I have received. But I did not represent the special, I am not the special PP Gauhati High
So
Court.
anyway, but can you just highlight or throw some light on it? The submission made by the land counsel for the petitioner, whether the practice is here that opening one day particular day is fixed for opening of the case, and then thereafter 60 days for discharge, filing discharge petition, giving an opportunity to the accused to file, and after that Okay, discharge after hearing that, and then the next day, framing of charge. Is it correct?
There is the practice, I believe, my lord. Now, in this case, my lord, if you
I have never come across, even in the records also, trial
Yes.
court record also, these.
Now,
Because
here, my lord-
normally what happen is, what we understand
Wow.
is that after filing of charge sheet, the court will take cognizance of the case, registered, and then issue notice to the accused, calling them, and then to furnish copy. First day, okay, furnish copy. If the person receive the copy of the police paper or the charge sheet, then they will ask whether would you like to engage an advocate of their choice or not. Then state defense. Okay, that is another day, and then thereafter a case will be, if they engaged, they have engaged advocate, then a date will be fixed for hearing on charge. On that day, before that, because they know that the next date is fixed for framing of charge or hearing on charges. Then in between, the accused, if they want, can file discharge petition, or on the first day also can make a request to grant liberty to file discharge petition. So in this between only they have to file, they can file discharge petition if they want. And if in the event of the discharge petition being filed by the accused, it has to be disposed of first. Thereafter only charge framing of charge.
correct.
So this framing of charge and discharge petition can be taken up together. Discharge petition will be heard, hearing on charge. On that day, discharge petition also will be heard. If succeed, discharge.
Agree.
If not, then charge will be framed. This is a procedure normally we understand
Agree.
and
I-
normally being practiced. Here I have no idea. The opening of case is fixed one day opening, and then how it would be recorded. I have never seen here also how that the court used to pass order on that day. That entire thing is to be recorded. He is going to there based on these evidence. I don't think that is available in any of the record.
My lord,
I have
if
not seen.
May I make one small
Yes,
submission,
please.
Your Lordship? If, let's assume for a moment that this order is correct. In the opening stage itself, if the court is allowed to frame charges, what about my statutory rights under 250 for filing application for discharge? Because interpretation, my humble interpretation of 251, the first word is if. The first word used under 251, framing of charge. The first word is the word if. If after such consideration and hearing as aforesaid. Meaning that before framing of charge, you must dispose of the discharge application.
See,
Meaning
at
that
the time of framing,
opportunity has to be given to us.
at the time of framing of charge, only you will be heard.
In fact,
Counsel for the accused.
before that, my lord, before that.
After hearing only, the court will be
My
passing
lord,
order.
my lord, this discharge application is a condition precedent for framing of charge. It has to be disposed of first, this way or that way. Only
Here
then
is
they
the-
can go ahead.
See, learned counsel, see, I'm telling again and again. Here is the case where you have not filed discharge petition. Yeah, in your case, have you filed?
On this particular date, no, but day after we file.
After that, how you can file also?
Then
You will not be allowed also.
All right.
Because
16
already charge framed.
All right. What your lordship is saying is, let's say we are both in agreement. This, if going by what your lordship is stating, this order has to go either ways because it is contradictory.
Contradictory in sense.
In a sense that, let's read again. Today is fixed for opening of the case. Accordingly, the court heard presentation of the special PP about the matter so and so. The court also heard a defense. After hearing both sides' submissions, the court find prima facie case to frame charges against so and so. So it goes on to frame charges. Let's look at the last line of the order. It says, fix 2907-2026 for framing of charge. Then what is this? It is contradictory. First, he's saying that I'm framing charges, and then he's fixing another date for framing charges.
No, so on that day, charge will be explained after framing, because now hearing satisfied, or he has found prima facie case, now he is ready to frame charge. For framing charge, the format he has to fill up.
Then what happens to my rights under 250? That is my statutory right. How can
This-
he just take it away? What happens to my statutory rights? For filing a
He
discharge?
has kept another day for framing of charge.
Correct.
This normally, what we do is on the same day charge used to be framed.
So,
If the court found prima facie
So-
case, but then probably is in a case, long case, because in the format you have to fill up
so what, so what,
two
going
head,
by,
one head, two head, three
going
head,
by what your,
and then more than one accused persons.
going by what your, going by what your lordship is saying, my interpretation of what your
Hearing was
lordship is
done.
saying is
Hearing
that
was done.
charges are yet to be officially framed.
Hearing on charges were done.
So what your lordship,
It indicates.
my understanding of what your lordship is trying to impress upon the council is that charges are yet to be formally framed. If that is the case, then please allow this petition, your lordship, then allow us to dispose the discharge application. I think everyone that way will be on the same frame.
It appears hearing was done, but then why he has written this framing of charge?
Exactly. That is what we're saying, my lord. It's very confusing.
This
It's very confusing.
because he found prima facie case first place, and thereafter charge would have been immediately framed.
Correct.
But
that is what our
again, framing of
understanding is
charge.
also, your
I
lordship.
didn't
That is
see
what
that.
my understanding is also. But unfortunately here, he's saying that I find a prima facie case.
Anyway, what we'll do is we'll see you also satisfy. What we'll do, we'll call for the record.
My lord.
Let us see, call for the scanned copy of the record, and then we'll just see. And if you could see, show the authority.
Your lordship, apart from that, if we look at section 251, that particular sentence is there if there is a ground for presuming that the accused has committed an offense, despite the charge is not yet framed till date. So
No. So here, actually, one part he has divided into two parts.
Yes.
One hearing done, prima facie found, and on the date probably it appears that there are more than one accused, and then more the charge also would be framed under probably 2-3 head. So he has kept another day for framing of charge and and explaining,
yes,
and then for explaining the accused person. It appears because hearing already done,
yes, a hearing.
but this
yes, as per the court, it
should
was.
have been on one day.
It merely says that defense counsel were also heard, but it doesn't specify whether we were heard under section 250 or not. But what I'm saying is, your lordship, still till now, charge is not yet framed. So within stipulated period of 60 days, we filed our discharge
See,
application.
just a minute. After hearing both, I have not read. Kindly let us read then.
Yes.
Today is fixed for.
Today is fixed for opening of the case.
Please,
Accordingly, the court heard presentation of the special PP about the matter of the case and how they are going to prove their case with evidence before court. The court also heard the defense counsels. After hearing both sides' submissions, the court find prima facie case to frame charge.
Yes,
So and so.
this will be.
So
Okay, then.
then thereafter, the learned counsel for the defense submitted that this is regarding whether 405 IPC criminal breach of trust and 415 cheating, whether it can coexist. And this issue should be later on resolved. That is what the learned trial court say. And the last paragraph is fixed so and so for framing of charge. So my humble submission is that since charge is not yet framed, and within the stipulated period of 60 days, we also filed the discharge application. So by invoking the inherent power of this honorable court, your lordship may kindly direct that, okay, despite this order, even without quashing this order, let the discharge application be taken up because charge is not yet framed.
Now, just a minute.
Yes.
Because this would, what I have not read. I thought that this is only a quashing petition. I thought that notice will be issued. I did not read this. I did not open even.
This is not for quashing, madam. This is not for quashing. This is only for invoking inherent power of this honorable court, only for that rectifying that particular issue. Because now I think we can simplify in that way, your lordship.
Just a minute. Okay, so this matter, it appears that special PP pressed for time into this matter, whether the aforesaid section, because you pressed for
Yes.
sections can coexist or not.
Yes.
Before deciding the matter for the end of
Another hearing is still to be there.
prayer of a special PP is granted. So he is granted.
Yes.
Then probably charge not yet framed, and then probably the half of the hearing still left.
Yes. Another hearing should be still there. To be
This should
conducted.
not, because once you find the prima facie case, charge should immediately frame on that day only.
Yes. That
But
is what
this has not been done here in this case.
Yes.
So there is a little chance. Let us see. Okay, we'll issue notice then in that case.
My lord, my
Yes,
humble,
we'll
my
issue
lord,
notice.
my lord, in the meantime, my humble prayer is that let the proceeding be stayed. Otherwise,
When next date is fixed? Next date,
It is-
29/7.
yes, it is to be taken upon this tomorrow, my lord. So otherwise, stay order is passed. Then, yes, only in respect of the present petitions.
Hard, Mr.
B. Lora Menga.
Land Council for the petitioner. Also hard. Who is for 1 and 2? No, for state, who is there 1 and 2? Just in first case. Otherwise, you are challenging the same order. Okay, just a minute. Sir. Okay, additional PP, state, additional PP for the state. Huh? And Mr. Standing Counsel for Lok Ayukta?
Yes, my lord.
Okay.
Mizoram Lokaयुक्त.
Okay.
Respondent number 2, special PP.
Standing Counsel, Special PP.
Special PP.
Special PP?
Mizoram Lokaयुक्त.
Okay. Mizoram Lok Ayukta. Stop, huh? By filing this application under 528 of the Bharatiya Nagarik Suraksha Sanhita 2023, the petitioner is seeking, no, the petitioner has challenged no, this is for modification. Challenge the order dated 24/6/2026. Passed by the Land Special Judge Prevention of Corruption Act 1988, IJO. What is the conclusion of this order then?
The confusion is that, Your Lordship,
This
Once-
is the conclusion. This is the conclusion, my lord.
was once the Lanet Trial Court had decided to proceed for framing of charge. That means our right to be heard under Section 250 of BNSS was taken away.
Whereby the Land Court has proceeded for framing of charge against accused petitioner. Without giving an opportunity to the petitioner for filing application for discharge. So we're giving an opportunity to file discharge petition. Huh? Stop. Huh? It is submitted that. Although the learned special judge has recorded finding prima facie case against the accused for framing charge against the accused for framing charge against him for offense. These all sections are for all accused persons. This prima facie case found against
Yes, my lord.
under section 120B, 409, 420
No, this one is for
IPC.
A1 and A2, man. For A1 and A2.
Hmm.
For accused number 1 and accused
And
number
under
2.
section 11, 13 within bracket 2, read with 13 within bracket 1, within bracket A and within bracket B of Prevention of Corruption Act 1988. Oh, this is what you are A1 or A2?
I'm A4, Your Lordship.
A4.
Yes.
Okay, just a minute. Then
A4 and 6 are mentioned together in this impugn order.
A4 and
A4 and A6 are mentioned together at the bottom of the page. Alphabet page A. my lord.
okay. Under section A4 and A6. Now against you, which section?
120B, 409, 420 IPC.
Okay, then leave that. That is with regards to A1, huh? Okay, then charge against the petitioner under section 120B, 409, 420 IPC. You are A4.
Yes, and under section 13.2,
Where?
There is next page, page B, at the top of the page.
Okay. And under section 13 within bracket 2, read with section 13 within bracket 1, within bracket small a and within bracket small b of Prevention of Corruption Act 1988. The charge has not yet been framed, and the next date is fixed for 29/7/2026 for framing of charge. Stop. The Learned Counsel for the petitioner further submits that in the meantime, the petitioner has filed discharge application
Yes.
before the Learned Special Court. Discharge application under section
250 BNSS.
250 BNSS, huh? Which is pending disposal before the special court. Start. Okay, issue notice. Since Mr. or Miss So-and-so and Mr. Miss So-and-so and accepts notice on behalf of the state respondent number 1 and Mr. So-and-so, and standing counsel for respondent number 2, accepted notice of respondent number 2. No formal notice is required to be issued. Stop. Para. Call for the scanned copy of the case record. Stop. Para. List the matter. When? Next week?
After 2
After
weeks?
a week.
After a week.
After a week, we'll say.
After a week, and in the meantime, if your lordship permit us to file written objection to this.
Okay. After a week, stop. In the meantime, the state, sorry, the respondents may file written objection. Stop. Para. In the meantime, the further proceeding of SRPCA number 2 of 2026. No, in the meantime, the hearing, the further hearing. It's a further hearing only. Hearing already
Hearing
done.
on
it appears.
discharge application, my lord.
But along with the framing of charge against us, my lord, it should be if it is not state. Along with framing of charge against the present petitioners, as well as hearing of the discharge application, it both have to be stated.
In the meantime, the further proceeding for framing of charge shall remain state till the next date of listing. Okay, next we'll fix then that after 1 week would be list the matter on
17 or 18?
17.
17.
17. Till then, the framing of charge shall remain state. Okay.
Highly obliged, my lord.
Second case is
My
the
lord,
same only.
This item, yes, just that I am A6, accused number 6.
A6.
In item
So
number
then
15.
here the
Charges
only
also the same.
Section will change. Yeah.
Section is the same, my lord, because
Section is same.
same, exactly the same.
Then the order will be same then.
Same, just
Then-
that it will be A6,
Hmm.
accused number 6.
Okay. Accused number 6. Name of the council changed. This will be, this is 14, 15. Third case 16
Third
is same.
case, my lord, this
And
is
here 8A,
A5.
A5.
But the charge
A5
is
and 4 are same only.
my lord, the charge is slightly different.
Okay. A4 and 5 appears probably same.
So A5 is
It's
slightly
A5 is same with the 4. Where is the order?
in my
Where
page
is the impugn
36. Page 36. Page 36 at the top, second line. A5 is there.
A5. Then section that's 120B, 406, 420 IPC, and under section 11. Right, A5, have you seen? A5, 120B, 406, 420 IPC, and under section 11, comma 13, within bracket 2, read with 13, 1A and B of Prevention of Corruption Act 1988. Okay.
Deeply obliged.
My lord, in this case, may I, if I may not be tedious to your lordship. Now, in the name of the respondent, I cannot represent the Mizoram Lokaikta.
Here.
Because the Mizoram Lokaikta has to be represented by the secretary. Here in the course title, it's mentioned the special PP Mizoram Lokaikta, the state of Mizoram
Oh, no.
represented by special PP. I think my another friend has to rectify that.
We'll make the correction, my lord. We'll replace that particular page.
The Mizoram Lokaikta has to be represented by the secretary. And I'll stand on behalf of the Lokaikta.
Represented by the special Mizoram. State of Mizoram.
The state Mizoram Lokaikta represented by its secretary.
We'll make the rectification, my lord. We'll just replace this particular page. With your lordship's permission.
Let them replace the course title, my lord, the name of the respondent.
The Learning Council for a petitioner praised for making necessary correction in the course title by including the state and the Lokaikta. Okay,
It's represented by the secretary.
represented by
The secretary.
the
The
secretary.
Secretary Mizoram Lokai
Okay.
in both cases.
The prayer is allowed. Huh?
Daily list for admission, item 1.
Your Lordship's indulgence, Your Lordship, in item 1, as per the order dated 8/6/2026, as per the order of this honorable court dated
Yes, yes,
8/6/2026,
yes.
my lord, we will see at para 8, the last para.
8, 6.
8/6,
Hmm.
last para number 8.
Yes.
That above being said, the learned additional AG is granted 10 days time to file an application impleading the Forest Department.
Yes.
The
Have they
state
filed?
respondents are directed to make an inquiry and give reasons as to why the compensation amount of rupees so and so in draft award 1 of 2022 has now been suddenly raised to so and so in the draft award number 1 of 2026. So, my lord, there are two parts. In the first part, my lord, I'm to file an application impleading the Forest Department. However, my lord, I'm not the petitioner in this case. I cannot file an impediment application. So I have asked the Forest Department whether they want to file an application intervening in this writ application. But till date, my lord, I have not received any instructions from them. So I'll have to be granted some more time, my lord, in that regard. Otherwise, it can be presumed that they do not want to be a party in this case.
No, if they are necessary party, then I think
No, my lord, they are not necessary party.
not a necessary
Not
party.
necessary party. There was an award. There was an award passed in favor of the petitioners, claimants, landowners, and that award has already been approved by the state government. And the paying authority, acquiring authority is the Ministry of Road Transport and Highways. So as for the
So
second,
who is, you are for the petitioner,
I am for the
but
petitioner.
it
my
has
lord.
to be implemented by the petitioner only.
No, my lord. This court has already heard this matter, and it is. I have already convinced the court in the previous occasion that it is not necessary for the petitioner to implead them.
No, but even if any order pass, is it going to adversely affect the forest department?
No, my lord.
No, just a minute.
They are-
Is
they
it
are
going
only-
to affect?
That is what I have been asking the Forest Department, but they have not replied till date, my lord. I have asked several times.
According to him, the forest department is not a necessary party.
Maybe not. Maybe they are not interested, my lord. I have written a letter also.
But any order passed against the forest department, if it adversely
my lord,
affect them,
Not at
then
all.
it
Not at all.
then-
It won't affect them, my lord. There was an award.
will not affect them.
It won't affect them.
It will
It will not affect them. my
not
lord.
affect them.
In as much as there was an award approved by the state government. The award was passed by the district collector, which is an independent body. Since 10 years back, that was already prevailed. And none of the authorities have put it to challenge that award. That award now attains finality.
Okay, by an order dated 8/6/2026, the Land Advocate General was directed, granted time to file an application for implementing the
At this stage, my lord, we're waiting for the
implement of the Forest Department. Today, Miss Linda Pambal, Land Advocate General, submits that although she has written to the Forest Department, however, the instruction is still awaited. Therefore, she prays for further, how much time? 2 weeks time,
2 weeks time, my lord.
staff. Huh?
I
Let
have,
them obtain, because
I have an
according to
objection
you,
my lord.
they will not be affected. Now let her obtain instruction at least.
She
Because
was
if
already granted
they
the
think
books
that they are going to be affected, let
My
them
lord.
come. If not, then I think, so next date, if they fail, then we'll proceed further.
Yes, my lord.
My
Okay.
lord, she was already
And then-
granted sufficient opportunity, my lord. This is, your lordship, which your lordship is referring to, is the order dated 8th of June. And even thereafter, my lord, she has been given 2-3 times, on 2-3 occasions, my lord.
Still awaited. She said
Still
it's still
awaited,
awaited.
still awaited. This is only delaying the matter, my lord. As for the second direction,
And then this second direction
Yes,
is
my lord. As
to
for the
inquire and
second
to give
direction,
region.
We have submitted the affidavit yesterday before the registry.
Okay.
So we'll have to check whether it passes through the registry or not.
Okay. With regards to the second direction, the
DC Longklai has filed
okay.
an affidavit.
Miss Linda, Line Additional AG submits that they have filed affidavit in this regard day before yesterday. However, the same is not before the court, not the record staff. The registry shall verify and place the same along same before the court on the next date. Staff is prayed for,
my lord,
further 2 weeks time is granted to Miss Linda Farmwell, Line Additional AG, to obtain necessary instruction. Staff, it is made clear that in the event of failure to obtain instruction on the by the next date, the matter will proceed based on the record available. Okay.
my lord, if the date may be shortened, 1
Okay.
week,
Then after 2 weeks would be
let it be 1 week, my lord. They have fully sufficient
in
opportunity.
the event of the failure, that will be to obtain an instruction on the next date. The necessary order will be passed in this regard. Okay. The court will consider passing necessary order in this regard. Okay. And as requested, list the matter on
17th,
are you also appearing here? Okay, Miss Sampuy, for respondent number 8. As requested by the counsel for the party, list the matter again on, it will be 25, 24. Today is 24. Sorry, 24, Monday. Okay.
Obliged.
Item 2.
Your Lordship. Lordship, notice is not yet complete.
Here, kindly just a minute. One sentence that according to Land Council for the petitioner, the Forest Department is not a necessary party. That also will be recorded.
not required, my lord.
Not required. Okay then.
Lordship, in this case, notice to the respondent is not yet completed.
Okay.
So if this matter may be taken after 1 week while waiting for the notice to be completed.
Okay. Mr.
Michael Paswell.
Land Council for the petitioner staff. The notice upon the respondent number.
Sole respondent.
Okay, sole respondent is still awaited in view of the council for the petitioner, Land Council for the petitioner. Submits that the matter may be listed after 2 weeks. The prayer is allowed. List the matter again after 2 weeks. Okay.
Job branch.
Item 3.
My lord, for respondent number 1. Payment is under process, my lord. If I may be granted 3 weeks time, then this person may be able to do.
Okay.
So, sir.
Okay. Mr. Victor Alrante, Land Council for the petitioner. Stop. Miss Jaram Sampui, Land Council. Miss Jaram Sampui, you are for respondent number?
Number 1.
Land Council, appearing on behalf of the respondent number 1. Praise for how much time you said?
3 weeks may be given.
For the 3 weeks time to obtain instruction and to file affidavit in opposition. And you are for? Have you filed affidavit? Already filed?
Yes.
Okay, Mr. Okay, Land Council for the respondent number 4. Appear on behalf of your senior's name? Your senior's name?
Miss Mary.
Okay, Mrs. Mary Waldroth Kemi, Land Council for the county, Medial County. Land Council for the respondent number 4 is also present. Staff. Is prayed for, 3 weeks further time is granted to the respondent number 1 to file in order to in order to facilitate her to file affidavit in opposition. Okay. Enable her to file affidavit in opposition. Okay. List the matter after 3 weeks.
Oblige.
Item 4.
Yes,
Paperbook is still awaited.
paperwork is ready.
We have not, it has not yet,
Not received.
not yet received.
Okay. And this is criminal appeal. You probably has need to pay the cost of the paperwork.
Last week we have paid the cost.
Date.
Paid.
Okay. Had Mr. Victor Ralty, land counsel for the appellant. Also had Miss Mariel County and Edison PP for the state staff. Paperwork is ready. Staff. The land counsel for the petition submits that the cost of the paperwork has already been paid. Staff. In view of the above come, the registry shall furnish a copy of the paperwork each to the land counsel appearing on behalf of the parties. Staff. List the matter after 3 weeks.
4 weeks.
4 weeks. Okay.
If you oblige.
Item 5.
May I please, Your Lordship?
Yes.
My Lord, TCR is arrived. I think paper TCR is arrived.
TCS. Okay.
Your Lordship, may I please pray for adjournment as my senior, Mr. Benjamin Lathamwana. Your Lordship, may I please pray for adjournment as my senior, Mr. Benjamin Lathamwana,
Okay.
who is the
So,
lead
had
counsel.
Mr.
Kay Kam Thian Manga.
Land counsel for the petitioner. Also had Mr.
Ronald Joza,
Land counsel appearing on behalf of Mr.
Benjamin Lathamwana.
Okay. For the respondent number.
Respondent number
7 to 8. 7 and 8. No. Okay. Then Miss Linda for respondent number. Okay, 7 and 8. You are for 1, I think. Who is your senior?
Benjamin Lathamwana. Or
Benjamin is
1
for-
and 2.
1 and 2. Okay, his name. 1 and Benjamin. Land counsel for the respondent number 1 and 2. And who else is present? What about the 3, 4, 5, and 6 respondent?
My Lord, she is on maternity leave and maternity leave. Miss Emily L. Changte.
Okay, Miss Emily. Who appears on her behalf?
4 to 6, even though Edicat is written, no one represent Lordship.
But the notice upon 4 to 6 complete. Okay. Although notice upon the respondent number 4 to 6 is stated to be complete, however, no one appears on their behalf. Stop. Para. The trial court record has been received. Paperwork prepared, not prepared. The registry was directed to. No. Okay. The registry is directed to prepare paperwork. Stop. List the matter after 4 weeks. After preparation of paperwork. Okay.
Item 6.
My lord, item 6 and 7, the council, the additional PPs on legs, my lord, if it can be passed over for the time being.
Okay. Unless.
Item 8.
8 or 8, 8 or 6. My only predicament is that, my lord, I want to catch a flight at 4 o'clock, my lord, today for Gauhati. So, my lord,
No, you just tell me
There's
once.
still time.
Tell me once whether is there any statement? Have you disclosed any case pending against you?
yes,
Or
my lord, there is no case pending. There's no case pending. No entry.
okay, where? Which paragraph you have stated?
My lord. My lord, para 7. Para 7.
Okay, no criminal antecedent. Okay.
My lord, here the 47 and 48 notices are given in Mizo language, whereas the petitioner is from Assam. Even in fact, this is a covered case, my lord, by a judge.
No, we'll have to see the record.
My lord.
here. See the record. This is 7. 6.
Yes. 6.
Where is 7? Here also you have made this disclosure statement.
Yes.
Antecedent.
Para 7.
Para 7. Okay. But then page 19.
Page 19.
Kailash is the petitioner.
Yes, page 19 of item number 7, madam.
Yes.
Page 19 of item number 7. It
Kailash is the accused.
Yes.
Yes. See, he has. Have you seen this written in Hindi?
Yes, it is written in Hindi. Now, my lord, for item number 7, my submission is different. In item 7, my submission is that 48 notice was never sent to the relatives. Total non-compliance of 48 notice. My lord, may kindly turn to
What about this then, page 22?
page 22.
Who is this?
This is 47. This is 47. For petitioner number
But
2.
page 19 is 47.
Page 19 is for petitioner number 1,
Okay. There are two petitioners.
2 petitioners. Now, my lord, may kindly come to
And what about this 25?
25. Now, this 25 notice was signed by the accused himself. It was never sent to his relatives. They say only a telephonic intimation was given, which is impermissible in law, my lord. Supreme Court Division Bench of our High Court have clearly held that grounds of arrest, Section 48 has to be in writing to the relatives, has to be communicated in writing. Specific mandate of 3 Supreme Court judgment, of 2 Supreme Court judgment and 1 Division Bench judgment of our High Court. This is signed by the accused himself, Kailash. And similar is page number 28.
What is your submission here in this?
My submission here is this notice was not served in writing to the relatives. Nothing was sent in writing to the relatives, which is the mandate of Section 48 as held by the Supreme Court and Division Bench of Appeal.
But you were informed.
My lord,
Informed.
my lord, information is to be given to me under Section 48 and to the relatives under Section
47 to you. 47.
to me and 48 to relative. Here is a case of total non-compliance of Section 48. My lord, may kindly take up that. My lord, this situation was dealt by this court, my lord. There is a small compilation I have given, my lord. This compilation will show that this in Mihir Raj, the grounds of arrest must be furnished in writing in order to attain the true and intended purpose. In Vihan Kumar Para 3, hence the requirement of communicating the grounds of arrest in writing is not only to the arrested person, but also to the friends, relatives, or such other person as may be disclosed or nominated by the arrested person, so as to make the mandate of Article 22(1) of the Constitution meaningful and effective, failing which such arrest may be rendered illegal. Then this is the division bench, number 3, division bench of our High Court. Thus, keeping in view the decision of the Supreme Court in Vihan Kumar, we are of the view that the grounds of arrest in writing would have to be made known not only to the arrested person, but also to the family members of the arrested person. This is the division bench of our High Court. Then, learned single judge, my lord, a similar matter came up where the submissions on behalf of the state was this. The learned public prosecutor further submits that since the applicant is from Manipur, it is not possible to give the intimation of arrest to the relative of the applicant, and that is why the intimation was given the applicant, and a phone call was made to the wife informing her why the applicant was arrested. Such being the case, section 40 of DNA has been duly complied with. That was the submission of the state. Now the observation of the court is on the next page. The above being the position, I find that the requirement of section 48 DNSS is not met in the process of arrest of the applicant. No material has been produced before this court that apart from the arrest intimation given to the applicant, a written arrest intimation was sent to his relative with or within or outside the state. In fact, in such a situation, if the relatives of the arrested person does not reside within the state or reside in a far-flung district within the state, the arresting authority could very well send the intimation of arrest in writing to the relative concerned by post, and also send a copy of the same to the officer in charge of the police station concerned where the relative resides for delivery to the relative. Now
My lord, if I may, my lord, before we proceed further, my learned friend is just wasting his time. My learned, the learned additional PP is on legs, my lord.
So let him submit, and will when she comes.
Because she
Because
has hearing.
His submission, he is to leave probably. So his submission. So later on we can see the record. Just okay.
Alright.
What else? What was she? You were informed.
In item 6, the language
In
is
this
completely
paragraph, he has clearly acknowledged and his production before the court also. This appears to be a substantial compliance of the requirements under notice. It appears. Anyway, we'll have to see the record whether they were explained how they have sent to the family.
Well,
Okay.
one of the only thing that perhaps your lordship will see that whether it was sent by post to the relatives. Because the mandate is, it has to be in writing. Rehan Kumar, Supreme Court has clearly said, because my lord, otherwise it is very difficult to know. In telephone call, my lord, who has said what, we have no documentation to that effect. Therefore, the Supreme Court has made it mandatory.
What prejudice goes to you? You have been informed. You were produced before the court. In the court also, you say that I'll be produced before the court in Hindi written. आज produce करेगा पूरा लिखा.
नहीं, but
So he has written in his own language. He was made explain. He was explained.
my lord, I am not on 47, my lord. 47 compliance, I am not arguing that. I am on 48 in item number 7. In item 6,
No, what prejudice goes?
Given, my lord.
Hmm?
If a date can be given, my lord.
When?
Thursday, my lord. Next 13th.
30?
1-3.
1-3?
Yes, next Thursday.
Okay. Next Thursday. Is it okay, Miss Mary? Okay. Let's pray for common list matter on 13. Similar. 11, 12 also.
No, my lord. It's
Just-
different. I'm
Item,
obliged.
item 12.
12 is different. Hmm? Different council. Okay.
May it please your lordship, appearing
Yes.
for the petitioner. My lord, this is also bail application and it is the first time of listing. So if it pleases your lordship, this notice may be issued.
Okay. That means?
Vandal Chandame.
Hmm?
Vandal Chandame.
Okay. Valentuata. Oh, Chandame. Valal Chandame.
Chandame.
Okay. Not counsel for the petitioner. Also had Miss Linda from Lana PP for the state staff. This is an application filed under section 483 of the Bharatiya Nagarik Surajya Sanhita 2023, read with section 37 of the ND and PS Act 1985, praying for grant of bail to the petitioner in connection, who has been arrested in connection with the excise case number, excise N160, excise number 169 2026. Is there any section also here?
Yes, your lordship. Under section 21C of Indian PSA.
Okay. Under section, where is that? Under section 31C of the NDPS Act. Stop. Issue notice. Since Miss something, Miss Linda accepted notice on behalf of the state, no formal notice is required to be issued. Stop. Call for the scanned copy. At what stage it is?
Your lordship, charge sheet has not been yet submitted.
Oh, it is the call for the case diary there.
I'll call for the case.
Scanned copy of the case diary. Stop. List the matter.
Next week, Thursday,
Thursday.
Thursday.
Okay, Thursday is date
13.
13. Okay.
13/8.
Okay. List the matter given on 13.
Item 13.
May please your lordship.
Hmm.
My lord, this bail application has also come up for the first time.
Okay.
So if notice may kindly be
Okay.
issued.
At what stage?
At the trial, it is at the stage of prosecution evidence.
Prosecution.
Yes.
Okay.
And one thing, my lord, I must submit, your lordship might want to consider dispensing with the calling of the records because there are two things that has happened here. Firstly, a co-accused has applied for bail before this honorable court, but he was rejected. Later on, another co-accused has applied for bail. We are on the same footing, and this honorable court had allowed him to be released on bail because of the violations of section 47 and section 48. I'm on the same footing with that particular person, and
Yeah.
I've annexed everything here in this charge sheet. So perhaps
Ground age also for on non-compliance of the
section 48.
section 48.
Yes.
Otherwise 47 compliant.
47. I'm not raising at this stage.
Okay.
Yes.
What is the offense?
22C.
22C.
Yes.
Okay. Hard Mr. It will be similar only. And also Mariel Kante, land additional PP. Staff, this is an application filed under section 483 of the Bharatiya Nagarik Surajya Sanhita. Read with section 37 of ND and PS Act 1985. Praying for grant of bail to the accuser. Accused himself is a petitioner.
I'm sorry.
Accused applicant.
Yes. Yes.
Who has been arrested in connection with which case?
SC bracket K
SCK number 21 2025 arising out of excise case number EXKLB stroke 283 stroke 2025 under section 22C NDPS Act 1985 staff. It is submitted. The case is at the trial stage. Case is at the case is pending before the which court you said?
Fast track court, Kolasip.
Fast track court, Kolasip.
Yes.
Fast track court, Kolasip at the evidence stage. Start. Call for and then issue notice. Since Miss So appear accepted notice on behalf of the state, no formal notice required to be issued. Start. Call for the scanned copy of the trial court record. Start. Okay. Yes, spread for comma list the matter again. When?
Your Lordship, record has to be called for, Your Lordship.
Hmm?
Records needs to be called for, Your Lordship. Scan copy.
That I leave it to your lordship's wisdom
I
because
called for.
Yes, yes. I thought my learned friend have told me that it's dispensed with.
No,
no.
I've called for the trial
Okay,
court
okay,
record only.
thank you,
Scan
Your
copy of the trial
Lordship.
court
Sorry,
record only. So when do you want?
On any week, on any day starting from 17th August.
17 August. Okay. 17 August.
Deeply obliged.
Oh, okay.